Okay, everyone, so we've launched the Zoom and the YouTube live stream, so the room is going to be muted. But just please a reminder, if you have a microphone and you're not sitting in the hearing room, that it is streamed right now. Thank you.
Tony, did you see the good news?
Huh?
You see the good news?
What's that?
Our plan was approved from,
Oh, yes.
I'll print it out and
Yeah,
have
we
it.
have to have Shamba sign it.
Yeah, I'm gonna forward it to everyone, but I will print it out and have it signed. Yay.
Remind everyone that we are already streaming until we begin at 10 o'clock, so.
That's what you can see.
All right, good morning, everyone. We're about to begin. We are already live. We're streaming on YouTube. Ms. Matias, are you ready?
I'm here. Yeah. Shall I start?
Hold on for Madam Chair.
Okay.
You ready, Madam Chair?
Please turn your mics. Everybody, please turn your mics on.
Okay, everyone, just make sure your microphones are on.
Is Commissioner Shabeta working remotely?
Yes.
I am.
Okay. so-
Can you hear me?
Yeah, sorry, I didn't see before. I apologize.
Okay.
Okay, Ms. Matias, you may proceed with the review session.
Okay. Good morning. This is the New York City Board of Standards and Appeals review session for April 15th, 2024. We'll begin with the board's proposed rule change.
Okay,
Item number 1.
thank you. So before we vote on this, I just want to give you an update. There was an additional language that was added to the proposed rule. And this was based upon further technical review of the proposed rule. There is a.
Sorry.
Okay. Just waiting for the echo to go out. Okay, so I can still hear it.
I don't hear it.
Okay. So upon further technical review of the proposed rule, BSA proposes to add reference to National Ambient Air Quality Standards, also stands for NAAQS, to section F2, little I, little b, and appendix B, industrial air quality checklist. Inclusion of NAAQS standards in addition to the DAR-1 standards already that is included in the proposed rule would account for pollutants of concerns such as particulate matter, for which standards are not included in DAR-1. And this methodology aligns with current practices for industrial AQ screenings. So this language has been added to clarify the standards that applies to air quality. And should we adopt this rule would be in effect as of June 3rd, 2024. So I make a motion. Do you have any questions or any clarifications, Commissioner? Okay, everybody shaking their head saying no. So I then make a motion to adopt.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Rule is adopted. Oh,
Thank
boy.
you, everybody.
Okay. Okay. The next items are adjournments. Item number 2, 1193 BZ, 4645 Kissimmee Boulevard, Queens. Item number 3, 2023 41A through 46A, 71, 73, 75, 77, 79, and 91 Longstreet Avenue, the Bronx. Deferrals, item number 4, 39747BZ, Volume 2, 64-01 Woodhaven Boulevard, Queens. And I apologize if you hear some buzzing, there's some plumbing work being done in the building. Withdrawals, item number 5, 2022-66BZ, 405 Arthur Kill Road, Staten Island.
Okay, the applicant is requesting a withdrawal of this application as a special permit pursuant to zoning resolution section 73-14 for a BESS, which is the battery energy storage system, is not required with the adoption of the City of Yes carbon neutrality. This text was adopted in December of 2023, and the text, as you know, the intent was to modernize the zoning rules to make it easier to install green technology, make energy efficient retrofits, install solar and wind energy system, and critically needed energy storage. So, and remove the barriers for the infrastructure that is needed to support such systems. So because of that, the applicant is requesting to withdraw this application. Do you want to add anything, General Counsel? Okay. All right, so I then make a motion to withdraw.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been withdrawn. Decision items, item number 6,
I'd like to
174.
add, sorry, I'd like to.
Oh, you
call
mean that you want to
item-
do South Conduit? I thought maybe we do it during the decisions.
Okay. All right, apologies.
Okay,
Continue. It's going to be done anyway today.
yeah,
Okay.
that's what I figured. Okay, decision items, 17494BZ, Volume 3, 9907 Roosevelt Avenue, Queens.
So we received submission from the applicant clarifying some of the questions that the board had asked. Did you all have a chance? And you're all okay with it? Good. Bless you. Bless you.
bless you.
I then make a motion to approve the extension of term and extension of time to obtain certificate of occupancy with following conditions. That certificate of occupancy shall be obtained within 24 months from the time of the date of this grant, and extension of term for 10 years from the date of the grant. The term had expired on May 2022, so, but I think I'm suggesting we started from the date of this grant. Is that acceptable to everybody?
Yes.
Okay, all right, then make a motion to grant.
Chair Shanda,
Sorry, just one second. Okay. All right, from the date of the last term is what we can only, this special permit was first granted, it was a variance that was first granted in 1997. It's on 11/4/1, so I just, okay, so it's from the date of the last grant. Okay, thank you. With that clarification.
So May 6, 2034, or
Yeah.
2032. 2032.
Yeah,
2032.
yeah,
Okay. Motion to approve, Chair Shanda,
aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye. Commissioner
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 7, 17803BZ4, 11402 Van Wyck Expressway, Queens.
Okay, we received the community board vote, voted to approve this with condition, and the conditions are that the operator continues to meet the requirements for fencing and landscaping as required by the existing variants. That is what the board was saying, prior grants and conditions that the applicant seeks to extend, and that the site lighting be directed to the site and away from adjoining residences. In addition, the applicant has also submitted its response to some of the comments the board had raised at the last hearing. With regards to the fire department violation, the applicant is already working with fire department in getting the necessary sign off. So is everybody okay with all the submissions? I then make a motion to approve an extension of term with conditions that fencing and landscaping shall be maintained. Lights within the site shall be directed away from adjacent residential uses and shielded as needed. Also, the applicant shall address all fire department violations prior to obtaining a certificate of occupancy.
Chair Shanda,
Aye.
Vice Chair Shabeta,
aye,
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 8, 2023-15A through 2023-18A, 8226 South Conduit Avenue, Queens.
Okay, so this is really very much at the last hour. We received a letter of withdrawal. We also received a community board vote, but the reason the applicant is withdrawing is based on a correspondence between BSA Council and DOB. DOB concurred with BSA Council that South Conduit Avenue is a map street, and thus BSA does not have to be involved. And the developer is responsible to pave the map street to DOT standards to develop the site. So, and this information was shared with the applicant, and based upon that, the applicant is requesting a withdrawal. So I make a motion to withdraw.
Chair Shanda,
Aye.
Vice Chair Shabeta,
aye,
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been withdrawn. Item number 9, 2023-60A, 39 Lunston Avenue, Staten Island.
Okay, just for the record, and this should be reflected in our resolution, the applicant submitted a revised application, and in that the address has been changed. It is now 43 Sharretts Avenue.
I think it's 453 Sherrod's Avenue.
Oh, is it 453?
Yeah, 453, yeah.
Oh, I'm
That's what
sorry,
he said.
I missed out the 5.
It's wrong in the lineup too, but
It's long, okay. So 453 Sharretts Avenue, so that's how the rest, it should be done. Our resolution should reflect that address. So the applicant has submitted revised application and updated the DOB objection sheet. And also we received a letter of no objection from fire department. So I then make a motion to approve this GCL 36 with a condition, and that is that planting as shown on the plan shall be provided.
Chair Shanda,
Aye.
Vice Chair Shabeta,
aye,
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 10, 2017-262BZ, 18 Stanwick Street, Brooklyn.
We need to defer it.
Okay. Decision items continued. Item number 11, 2020-51BZ, 2020-52A, 2020-53BZ, 2020-54A, 95 and 105 Ridgeway Avenue, Staten Island.
Also need to be deferred.
Item number 12, 2021-71BZ, 10531 76th Street, Queens.
Okay. So we received a secret sign off, and we also received the plans. I then make a motion to approve the bulk variance to develop an as of right house of worship with the following conditions. That the rooftop area shall be not accessible to congregants except for maintenance and repair and emergency purposes. Similarly, no gathering shall be permitted along the rear lot line. There shall be no noise amplification in the outdoor or rooftop area. All site lighting shall be directed down and away from abutting residential lots and shall be shielded as required. Windows along the northern lot lines shall be inoperable and opaque and shall have a minimum 28 STC rating. With that, I'm also going to add DOT conditions, and those are applicant or DOB is required to submit builder's pavement plan and all the required drawings as per New York City DOT specification for New York City DOT review and approval. All existing curb cuts along the side street frontages will be closed through reconstruction as full height curbs and sidewalk. The applicant will be responsible for all costs associated with the design and construction of site-related improvements, and New York City DOT will participate in the review process relating to all the future modifications, including any geometric alignment, sidewalk, signal, crosswalk, and pedestrian ramps. So with that, I make a motion to approve.
Chair Shonda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yu.
Aye.
Application has been granted. Item number 13, 2022-95BZ, 1249 Sutter Avenue, Brooklyn.
Okay. Seems to be becoming a pattern. The applicant is requesting to reopen the case. We had closed it when did we close it? In January. Because the applicant is proposing to revise the plan and its associated documents. And the applicant stating it needs to revise these to incorporate the recommendations that were made by the parking and site circulation assessment that was conducted by a consultant. And in addition to that, there are other changes that the applicant is proposing to make. I think some of those are good. Some of them needs a little bit of discussion and clarification. I would though say the applicant has submitted latest site improvement photos and they are coming along pretty well. I have from where this site started and where it is now, it is significantly better. And I do want to thank the applicant, the operator, property owner for taking our comments seriously and addressing those. So I make a motion to reopen. I don't think we will hear it now. We will schedule it for another day and we'll review and can opine on these discussions. Okay, motion to reopen.
Chair Shonda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yu.
Aye.
Okay. Item number 14, 2023-2023, Moses, 2023-23BZ.
Before we move to the previous case, I just want to also bring to the attention that we did receive a letter from the neighbor with a bunch of videos that was taken from, I guess, their security camera. And there was an issue that they brought up which had to do with some safety security concern. I would strongly suggest don't wait for the next hearing. Try to address the issue while we are still in review mode.
Yeah, the neighbor actually praised some of the improvements that were done, and he expressed concerns about others.
Right, and I think this is good for their own business also.
yeah.
So they should try to look into this as soon as possible. Thank
Okay, so those comments were for 2022-95BZ, 1249 Sutter Avenue, Brooklyn,
you. Yes,
just for the record. Okay,
yes, thank you.
okay, so now move on.
Yes, please.
Okay. Item number 14, 2023-23BZ, 295 Exeter Street, Brooklyn.
Okay. We received revised plans with notes that we had asked the applicant to consider. Are you okay with that, Commissioner
Yeah,
Shelton?
I looked at it.
All right. Everybody's okay with it? All right, then I would make a motion to approve with conditions that removal of exterior walls and or joist in excess of those indicated on the BSA approved plan shall void the special permit. With that motion to approve,
Chair Shonda,
aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 15, 2023-24 BZ, 1046 East 22nd Street, Brooklyn.
Okay, we received revised plans and zoning analysis. Everybody was okay with the revision? Okay, thank you. I then make a motion to approve with the following conditions that removal of exterior walls or joist in excess of those indicated in the BSA approved plans shall void the special permit.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 16, 2023-65 BZ, 241 Freeborn Street, Staten Island.
Okay, the applicant has responded to the comments that were sent.
There was no submission required, I believe.
There were no submission, but they did submit the approved DOB plans, and the architect of record also stated that DOB had reviewed for flood compliancy with Appendix G. And the statement of fact was also revised to beef up the argument that we had asked them to. So those have been done. Okay, so I then make a motion to approve this special permit pursuant to 7371.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 17, 2023-72 BZ, 8615 257th Street. 257th Street, Queens.
So we received the revised DOB objection sheet. And zoning analysis sheet also has been revised. Everybody's okay with the submission? So I then make a motion to approve this special permit pursuant to zoning resolution section 73-621.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 18, 2023-73 BZ, 926 East 23rd Street, Brooklyn.
No submission was required. We did receive additional letters of support for this application. So I make a motion to approve with the condition that removal of exterior walls and or joist in excess of those indicated on the BSA approved plan shall void this special permit.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Appeals calendar, continued hearing items. Item number 19, 2023 40A, 99111 Sutton Street, Brooklyn. I emailed the commissioners the fire department report. They did an inspection some time ago, and I emailed you a report. I don't think you're going to have time to read it, but
I did not get the time to review it. We just got it.
yeah. It was done on December 19, 2023, the inspection.
So, that's a lot to read into the record. I need to read it to understand what should be in the record.
Do you want me to read it out loud, or are you going to read it?
You can read it out loud. It's
Okay. Dear Chairperson Shanda and members of the board, the Bureau of Fire Prevention inspected the above premises on December 13, 2023, and found the following conditions. Upon arrival, we immediately identified an illegal lock on the front gate obstructing the path of egress, leading from the basement level to the street level, and a dumpster with trash obstructing the path of egress on the left side of the building. We continued around on the left side of the building and identified through One of the windows, construction was being done in one of the apartments with no permits posted from Department of Buildings. We gained access in the building and began conducting a full building inspection of the premises, starting with the basement. During our inspection of the basement, we identified multiple fire code violations from the storage of combustible, waste obstructing the path of egress, material stored to close to the sprinkler detector heads, missing exit identification signs, and sprinkler valve room without proper identification signage. During our inspection, the basement we met with the superintendent, Mr. Nunez. We informed him that we were conducting a full building inspection. He granted us access to the electrical room and sprinkler valve room, where we identified a large amount of combustible storage near the boiler and throughout the sprinkler valve room. Sprinkler system was operational with all valves in an open position. We asked Mr. Nunez which apartment construction was being done. He informed us that no construction was being done. It wasn't until we showed him pictures, we took of the room that he showed us the apartment number 5 was under construction with no DOB permits. While conducting our inspection of the building, we identified that each floor had an excessive amount of apartment doors fronting on the public hallway. According to the building's certificate of occupancy issued by the Department of Buildings, the building should have a total of 48 dwelling units, 10 basement, 8 first floor, 8 second floor, 8 third floor, and 14 fourth floor. We identified a total of 64 apartment doors, 11 in the basement, 12 on the first floor, 12 on the second floor, 14 on the third floor, and 15 on the fourth floor. While conducting an inspection of each floor, we also identified multiple code violations from illegal locks on the roof access latch. Floors were not properly labeled with identification markings and no re-entry access to the secondary egress stairwell. While upon completion of our inspection, we issued 4 FDNY summonses for all violations identified and sent a referral to Department of Buildings for construction work in apartments without permits. The path of egress leading from the first floor of the building to the street was inaccessible due to the removal of the staircase and adding a handicap lift, laundry room with flex pipe on gas dryers in the basement, and extra apartments in each floor contrary to the certificate of occupancy. And then the summonses, do you want me to read them?
No, that's okay.
Okay, so they're on the screen.
Okay. Thank you. Wow, quite extensive. I want to thank Fire Department for doing this inspection and providing some additional light to this situation. I just want to note that the lineup note still incorrectly states zoning districts. It should be M1-2.
What is it?
Yeah. The initial hearing on this application was held on December 2023, and board had asked both DOB and the property owner for further clarification. I just want to remind everybody listening in and commissioners and everyone that the action before the board is to consider DOB's request to modify the 2012 CO to remove the 10 Class A apartments that are located in the basement of a 5-story building at the subject site. So this is really an amendment of a certificate of occupancy. I have to say we received a very thorough set of documents from both parties. Also please note that Sheldon Lobel PC is representing the owner. So we did receive submission from the team. So upon review of all the documents that's been submitted, here are my questions and comments. So 99 Sutton Street property owner in its response stated in support of the review procedure that was undertaken with respect to filing at DOB that led to the issuance of a certificate of occupancy in 2008 and also in 2012. The property owner provided a letter of opinion from MJM Architects stating that all agency inquiries were responded to by the owner and was legally satisfied. Then the owner's rep further analyzed all the reviews and questioned the application of the controlling law regarding basement unit not being authorized by the board. And upon review of these documents and going back and forth between what the loft board rules say and MDL, this is some of my takeaways, and I want to read that out. The owner's rep questions the application of MDL 281.5, which was adopted in 2010 and was in effect when 2012 certificate of occupancy was issued. However, for 2008 certificate of occupancy, it was not in effect. And since the loft board legalized the IMD based on the residential occupancy prior to May 1, 1987 MDL 87, therefore MDL 281.4 applies and not 281.5, and MDL 281.4 does not refer to basement or cellar. So to that, here are my, as I look through the documents, though MDL 281.4, which applies for units residentially occupied since 12/1/1981 for residential purposes since 4/1/1980, it requires that units meet the definition of IMD as defined in subdivision 1 of 281. And MDL 281.1 subdivision defines IMD, and I want to focus on subsection three little i's, which states on 12/1/1981 was occupied for residential purposes since 4/1/1980 as residents or homes of any three or more families living independently of one another. I want to highlight that, living independently of one another. And the term living independently from one another stated in defining IMD units in the MDL sections is a defined term in the loft board rule that requires, among others, a unit with its kitchen, bathroom, sleeping area, and living rooms arranged to be occupied exclusively by the members of a family and their guests. So it basically means it has to be an independent unit. It is not a subset of a unit. So based on loft board's definition, these units in the basement/cellar were not recognized as residents with families living independently from one another, as evident in the fiscal year 2001 loft registration. In that, 31 units were registered, which matches the 2008 approved plan. It did not register the units in the basement or cellar as separate units because it did not meet the definition of living independently from one another. So as stated by DOB representative at the last hearing, for units to be considered for IMD, a kitchen, a three-piece bathroom, gas work would be needed to legalize it. And the rooms in the lower levels of the duplex unit lacked that then in 2008 CO when it was issued. So for the units in the basement to be covered under Article 7C 29 Rule of City of New York, Section 2-08 G1II needs to be considered, which is regarding additional units in building that have IMD units. It requires that such units need to meet the criteria of MDL 281.5. So if you're already an MDL, if you're already an IMD and you want to add units to it, under Article 7C, it says you can do it provided you meet the criteria of MDL 281.5. And 281.5 does not allow residential units in basement and cellar. And this request was made after 281.5 was adopted. So I think if you look at a sequencing of it, I would agree with DOB in this case that we should modify the certificate of occupancy. Now, with regards to cellar versus basement, so I went through my good old textbook of zoning resolution and looked through the definitions of cellar, basement, what is a street wall line level versus what is a street wall line. And based on that, zoning regulation definition regarding cellar and basement relies on base plane. To determine base plane, it relies on street wall line level and street wall line. In the case of 99 Sutton, the subject building is located on the front lot line. And the areaway, as shown on the survey, is located outside the lot line. It is on the city sidewalk. So based on the zoning resolution's definition of these terms as established prior to 2000, I want to be clear on that because the zoning was already then in place. Using the areaway in this case to measure the base plane is incorrect because you're measuring, you cannot do it. It's not within your property line. If the building was set back from the lot line, then you could possibly, but in this case, it's on the property line. So with regards to the basement versus cellar, as demonstrated by DOB at the last hearing, the lower level qualifies as cellar. So based on all the evidence provided both by the applicant, by DOB and the property owner, my position is that DOB's request is justified. Vice Chair Shibeta.
Thank you, Chair. I want to thank both the applicant and the DOB for their very thorough response. That being said, I do agree with the Department of Buildings position and agree with the statements that you've made. I have nothing further.
Okay, thank you. Commissioner Otley Brown.
Chair, I think you've summed it up greatly here, and I fully agree with you. And I believe that DOB has demonstrated that they have the right to modify the C of O.
Thank you. Commissioner Sheta.
Thank you, Chair. I want to thank you for that very thorough analysis that you just presented. I want to highlight that for me, there was three news in the latest submission from both parties. The first one is the applicability of the MDL 281.5, and I do strongly agree with you that the modification that excluded the cellar / basement that was done around 2009 is applicable, and I do believe that the DOB's position that they need to modify the certificate of occupancy is valid. The second thing regarding whether the lowest floor is a cellar or a basement, I do believe that it is a cellar. However, I want to highlight that both parties indicated that whether it's a cellar or a basement, it doesn't make difference for like that point before us.
Right.
The third thing, I do believe that, and I did read this in the latest submission that we got from the respondent, that because of like the multiple revisions that DOB and / audits that DOB has done and concluded the same conclusion like 3 times or maybe even more. Even with a case like this, I do believe that if DOB or whoever finds out that they made a mistake, even if it's 1,000 times, and it's clear that they made a mistake, I believe they should be entitled to correct it. Based on that, I agree with DOB that the certificate of occupancy need to be modified. Thank you.
Thank you. Commissioner Yoon.
Thank you. I agree with everything that's been stated wholeheartedly, and I thank you, DOB, for a very, very clear response twice, and the applicant as well. But I think it's important whether or not cellar versus basement applies to the legality in question here. It is important that it is amended on the C of O for the building's lifetime from here on out. So I agree with DOB. I believe they did make a mistake, and it is in their right, and it is important that they modify the CO, both to, I guess, indicate that the basement units are not legal and that the lowest level is indeed a cellar.
Thank you.
Can I add some credit to DOB?
Yes, you may.
Yes, it's some credit to DOB. I joined this board back in 2017. Back then, I do believe that every maybe other hearing that I criticized strongly DOB for what they do. I believe now they are doing amazing. I really appreciate the change. Seriously, I really appreciate the change. Keep up like very good work. And clean up whatever you got from the back. That's what should the DOB of New York City be. Thank you.
Aye.
Okay,
Thank you.
move on.
Move on. So I just want to, can I take
Okay.
a 5-minute break? I just want to consult my general counsel.
Make sure your mic is off, please.
Okay, all right. 5 minutes is up. Okay, let's go to the next case.
Special order calendar, continued hearing items. Item number 20, 50880 BZ, 6220 14th Avenue, also known as 1383 63rd Street, Brooklyn.
Okay. Initial hearing on this application was held on February 26th. Board asked for some clarification, and fire department has recommended that the has made recommendations regarding fire safety measures. So I think we have the revised plan, which is in response to the fire department comments and board comments. I think fire department also, yes, fire department issued a letter of no objection based on the revised plan. So I was satisfied with the submission. Vice Chair Shibeta.
Thank you, Chair. I'm also satisfied with the submission.
Thank you. Commissioner Otley Brown.
I'm also satisfied with the submission.
Thank you. Commissioner Sheta.
I'm satisfied with the application as it stands now. Thank you.
Thank you. Commissioner Yoon.
Thank you. I had no comments.
Thank you. Okay.
New
Next.
cases, item number 21, 41-02 Main Street, Queens.
Okay, this is an extension of time, so a proof of service of initial filing and hearing is not required. Applicant is seeking an extension of time to obtain a certificate of occupancy for a previously approved variance to permit the operation of a non-commercial art gallery community facility space in an office use located on floors 2 to 5 within a subject 5-story mixed-use building. The reason the applicant is seeking this is while DOB did approve it's in the process, the applicant has submitted the filing for new CO, but there are some open jobs related to the ground floor use, and those need to be closed prior to a CO can be issued, and the applicant is requesting a 1-year time to obtain that CO. I have no comments. I'm quite satisfied with the application. Vice Chair Shibeta.
Thank you, Chair. I too have, I'm satisfied with the application. My only concern is if we should give them a longer term, I'd like to a longer extension because I'm not sure that 1 year would be enough considering the plans that are still out there on the Starbucks tenant. So other than that, nothing further.
Sure, I'm okay to give if everybody's. I'll throw out a number. Typically, we do 18 months and 24. So I'm okay with 24. That cover. I think that should cover all bases.
I agree with you, Chair.
Okay. All right, Commissioner Otley Brown.
I have no questions for this application, and I'm okay with the 24-month term extension.
Okay, thank you. Commissioner Sheta.
Thank you, Chair. I have no comments. They asked for 1 year. I'm okay with 2 years extension. That would give him like
Okay.
some extra caution.
Okay.
The only thing I want to say that we received a revised statement of facts recently on Wednesday, and it came without cover. I'm not sure why. But I had to put the 2 statements, the previous one and the current
Oh,
one.
sorry about that.
Okay,
No, that's okay. But like, I like ask the applicants, if you submit something, please submit a cover with it to describe the changes. It's much easier for us to go through.
yeah.
I'll check that, but I thought there was a
I think
cover with
maybe
it,
it
but
was
okay.
submitted, it just, maybe the document didn't get uploaded to the.
Yeah.
that's possible.
Ma-
But please do, project manager, please do check and make sure whatever is updated, because it does help for the commissioners to review when they get revised documents while we are in the process of reviewing what changed, so that we are not going back and reading everything from the
Okay, sorry about that. Okay.
Commissioner Yoon,
Thank you. I had no comments and I'm fine with 2 years.
thank you. All right. I think, yeah.
Zoning calendar, one more. Zoning calendar, new cases, item number 22, 2023 71BZ, 504, 510 East 62nd Street, Manhattan.
We received proof of filing of initial initial filing and hearing notice. Community Board also has recommended approval of this application. This is an application for a waiver of sign regulations pursuant to zoning resolution 7221 to permit construction of a sign for Schwartzman Animal Medical Center, SAMC as a short form. And the applicant is requesting a waiver of the sign height. Zoning resolution permits signs up to 40 foot above the curb and non-illuminated signs up to 58 foot above the curb in a C8 district. The applicant is requesting more than that. And the applicant has provided its justification and therefore needs a variance. The proposed height of the non-illuminated would be an indirectly illuminated sign on the western facade of the building that would reach a height of 134 foot from the 134 feet 7 inches from the curb level. The applicant is entitled to a deference based on that, the applicant has provided his reasons, stating that because of the unique physical condition of the site, way it's located, it is very difficult to see this building from various access points for those who are driving to the facility or those who are walking to the facility. And the applicant provided very thorough route maps and laid out the ways certain signs would be readable. And if you've gone to the site, it is extremely hemmed in by FDR Drive on one side. There's a hotel right in front of the building. There is I think it's a pre-existing legally non-complying sign. And then you have which kind of makes it difficult to, I would agree that there is a difficulty in seeing this building, especially now it's under construction. So visualizing it becomes challenging. So the statement of fact lists 9 routes for which the wayfinding solution has to be designed. And that routes 2, 4, 7, 9 would benefit from this proposed variance. So upon reviewing the site, these are my thoughts. I feel Route 9 would benefit from the proposed relocation of SG007, which is located on the south facade initially, and then the proposed SG 9, 10, 11 sign. But I'm not sure about SG 12 sign, which is the proposed sign that the applicant is proposing to locate fronting on York Avenue, closer to the intersection of 61st Street and York Avenue. In its statement of findings, the applicant states that the Queensboro Bridge obstructs the view of SMAC building from certain pedestrian vehicular locations at 59th Street and York Avenue. And if the sign was positioned at a compliant height, it would be obstructed by the bridge, making it challenging to identify the building. And this is with regards to route number 4. While the proposed relocation of SG07 would not be visible because of tall trees, those traveling northbound on York Avenue will also not benefit from the proposed SG12 sign, I think. And this is based on my site visit. I drove, I walked just to get a sense of what the proposed sign would how the proposed sign would be visible. The side profile of proposed SG12 sign will be visible. Not sure if it will be legible or sufficient to give anybody a wayfinding. So I would like the applicant to provide a rendering, a video to support this argument. I understand the need to lower SG07 to improve the visibility for vehicles exiting from FDR Drive northbound to East 61st Street. I also, though, think the existing location of SG07 on south facing seems to be like the area that is most visible to all of those who are traveling northbound on York Avenue, even from East 59th Street, when York Avenue is at a much higher elevation and the ground slopes down to northward. Regarding Route 7, 61st Street westbound, regarding Route 7, 61st Street is westbound. So SG12 sign will not benefit those vehicles traveling westbound on 61st Street. Proposed SG12 sign would be visible to only pedestrians once they are near the corner of York Avenue and 61st Street. I had to stand pretty much at the corner of York and 61st Street to see that sign. When I was approaching the sign from 61st Street on the northbound, on the north side of the sidewalk, I couldn't see it. However, if I was on the south side of the curb sidewalk on 61st Street, I could see that. I could see that sign. And same with York Avenue. If I was on the west side of the sidewalk, I could see the proposed sign. I couldn't see it when I was on the, I wouldn't be able to see it as I was trying to visualize it when I was on the east side of York Avenue. So I would say, and also the applicant also stated that the Bentley Hotel obstructs the building's western facade along York Avenue and creates an obstruction for wayfinding, especially for those traveling to SMAC from 62nd Street. And this is specifically being referred to Route 9. 62nd Street is eastbound. I would like the applicant to clarify why the proposed as-of-right SG 9, 10, 11 illuminated sign on western facade would not be able to provide a wayfinding for those traveling eastbound on 62nd Street and would need to rely on the proposed sign on the other side of Bentley, on the east side of Bentley Hotel. Sorry, on the south side of Bentley Hotel. So those who are traveling also southbound on York Avenue, they would actually first see SG signs 9, 10, and 11, and they would have passed the entryway of the SMAC building that is on 62nd Street if they are trying to look for the wayfinding sign that is proposed for variance. So I think the application needs to be revised or clarified in terms of what is really the intent of SG12. I think more than SG12, SG7, where it is today, though it is under construction, so it's been removed, where it stands today or prior to the construction, with the additional wayfinding signs that is being proposed on the lower level, would be probably more in support of what the applicant is trying to justify. So maybe I'm not understanding this very thoroughly. Maybe I'm visually not able to see it. So it would be very helpful if the applicant can provide a video and a rendering of it. Actually, I uploaded a video from one of my site visits, so if you have had a chance to look through this. With regards to self-create, with regards to the neighborhood character, I don't have an issue with this, and with same thing with self-created. I think everything hinges on the minimal, and I stated my reasons. So those are my questions. Vice Chair Shibata.
Thank you, Chair, for that very thorough review. I have not been able to do a site visit, but I am looking forward to reviewing your video. I know it wasn't up when I checked this last week, it wasn't up on the site yet, but I have nothing further to add. I
Okay.
agree with your statements.
Okay, thank you. Commissioner Otley Brown?
We've actually had other cases of signs where, in order for the applicant to make their point, they've superimposed the actual proposed signage on the building and then done a video showing the approach to underscore their argument. And I think that would be very helpful here because you're looking at plans and you're not quite sure how those plans actually translate into action when people are either driving up the street or walking. So I think that's the one thing that they need to do. As for the overall ask, I really think it's very reasonable. We've seen it before with many hospitals needing wayfaring signage, especially within the borough of Manhattan, because there are so many distractions between other buildings and other activities and motor vehicles and buses that you really need to highlight the area where you want people to actually approach and enter the building. So I really have no problem with this, but I think that it would be to the applicant's benefit to provide renderings and videos to show why it's necessary.
I agree with you, Commissioner Otley Brown. I do think the way it's been presented has not been helpful, and I had to rely on my ability to kind of view it. And I think a video kind of playing that out would be very justifiable. I like I said, I think the one that I've submitted, applicant can use that if they want to use that to superimpose the video, the signage and play it out from especially the approachway, northbound approachway from York Avenue and pedestrian approaching eastward from on 61st Street. Those are the two places where really this proposed sign is going to be a benefit if placed properly. Thank you. Commissioner Shetta.
Thank you, Chair. I do believe that the ask is reasonable. I believe A is there, funding A is there. The facility is a nonprofit. The circumstances and the conditions around the site are kind of unique, including like tall buildings and neighboring buildings obstructing views to the existing signs. I don't think that this proposed signage change is going to impact the character of the neighborhood. I don't think there is a self-created component here. And I do believe that the ask is very reasonable. So I believe that it's a minimum variance, especially with the requested elevated sign. They are offering lowering one of the signs that's non-compliant for now. I believe a video is a good idea. It's gonna help their ask, and it's gonna, although I'm convinced, I do believe that adding this video component would be very helpful. I have two questions. The first one, whether they have any violations for the existing non-complying signs.
Can you repeat the question?
Yeah, if they have any violation or violations for the existing non-complying sign. And the second one, I know, and forgive my ignorance, I know illuminated and non-illuminated signs, but I'm not sure what is indirectly illuminated. Is it like you shed light on it from like outside source, not from the inside of the sign itself? Just I need to, it's not going to impact my position on the application, but I just want to learn what is an indirectly illuminated sign, if they can clarify that.
Okay. Thank you. Commissioner Yoon?
Thank you. I mean, based on what I understood from the application, the indirect illumination is that the letters themselves aren't illuminated, but there are lights behind these letters. And so there will be a glow behind the letters.
It's a very modern signage technology that I'm noticing. So these signs are not, they're kind of, they're a few inches in front of the wall.
Yeah,
where
they're
it's
held off the
mounted,
wall and then there's a light behind
and there's
it
a light
that makes it
behind it.
glow.
So which almost like you see it's like a negative, positive, negative kind of superimposition.
Okay.
And then at night, you kind of see just the glow of the light around it, which kind of gives it that And I think it would be helpful if they can provide
Yeah.
that rendering, but it's
I
a very,
think,
it's a very, now it's becoming a very common thing I'm noticing, as a sign.
I actually believe direct illuminated signs, the light source is within the sign itself, and indirect illuminated signs have a separate light sconce that reflects onto the light. So
that's
the
what I
applicant-
understood. when I went
Like,
to-
The
it-
applicant
I got
should
it.
clarify.
Like it
Okay.
can be from another building, it could be looking down into
Okay.
it. I remember there was one that we had done, which was a sign that was on, this was by the Roosevelt Avenue tramway. They had an indirect light source that was hung from the top
Okay.
on that.
So
So that's an old
maybe
fashioned, that's an old fashioned.
it's a reflective material that
Yeah.
the letter
Yeah.
is written with.
Yeah.
Okay,
But the applicant could clarify that, yeah.
Okay.
thank you.
Thank you, Commissioner
Yeah,
Yoon.
no, I just thought, that's what I thought they described
No,
in
it's,
their statement.
that's why you are the architect.
This is why I'm the architect. I agree with everything that's stated. I don't think it's a huge ask. I just don't understand the reasoning. It doesn't make any sense to me why the sign that's being proposed up here is going to promote wayfinding from the routes indicated. You know, if you're coming down, I didn't go to the site myself, so I'm relying on photos that were submitted as well as Google Maps, but you can see the lower level that's under construction and then the proposed expansion on the upper part of the tower. And as you're coming past this large building on 61st Street going eastbound, I'm not sure why a complying sign at 58 feet would not also achieve the same purpose as the one that's being proposed at 134 feet. Again, I don't think it's a huge ask. I just don't understand why it's actually helping. And if it isn't, if you can achieve the same thing with a complying sign, then I think we should consider that.
The only thing is nobody can come down 61st Street because it's a westbound street. So nobody would be in the middle of the road.
I understand, but they do talk about pedestrians coming down 61st Street eastbound, and so that's just, you know, you cited a couple of routes. I think generally, I'm not gonna go through all the routes and say why I am skeptical, but it's, as everyone else has stated, it's up to the applicant to show us, because we're not, all of us seem to be not clear why it's helping.
Okay. Thank you. Okay, I think that completes our review session. We should go back to our public hearing.
Sorry,
No?
sorry. Yeah, no, this completes the public review session. Do you want to take a break for a a public hearing, or you want to move on?
Do you want to take a break or do we just
DOB is
start
here.
with the DOB?
We can continue.
We usually give them a few minutes so they can prepare after our review. That's
Okay.
what we.
Let's give, we are at 11 o'clock, so let's wait till 11:10 and 10 minutes, we'll resume.
Okay. So we're going to resume at 11:10 a.m.
Okay.
And said that Hillary, the sign case applicant, and she said, will the review session for SOC and BC calendars happen after? I didn't hear anything about my case. I have been on all morning. What? Wasn't
Ms. Matias, are you ready?
Yes, I am.
We are live, Ms. Matias. You may proceed with the public hearing.
Good morning. This is the New York City Board of Standards and Appeals public hearing for April 15th, 2024. The first item up is Appeals Calendar, continued hearing item number 19, 2023, 40A, 99 111 Sutton Street, Brooklyn.
Okay. We have a representative from DOB. And
Is Mr. Schmidt in the room?
yes, Mr. Schmidt is in the room. You may,
Yeah, we don't have to swear in, so.
you don't have to be sworn.
Yeah,
I-
Mr. Schmidt, if it's your application, you may
I
proceed.
just want to make sure owners,
Oh, I'm sorry.
I want to
It
make
would
sure
be, Alexia Landsman,
we do have,
Richard LaBelle.
okay. Okay.
Alexia, do you want to, anyone else, Richard? I don't think so, right?
Robert Scarano, the architect who was is familiar to the board and worked on the application, is also available to testify. I know he was trying to log in.
I don't see him yet.
We just got off the phone with him. It should be momentarily.
Okay.
Let's wait for Mr. Scarano to join in. Will anyone else from DOB be joining in?
I believe, Felicia Miller is,
She's, okay, all right, thank you. Do we have Mr. Scarano in the?
I don't see him in the room.
Yeah, we don't see him in the room, Mr. Lobel.
Okay. I'm-
Can we start without him, or do you need?
I think we can start without him. I think Ms. Landesman, if you want to make efforts to obtain Mr. Scarano's attendance, I'd appreciate it.
Can somebody raise the volume of the hearing room? I think the hearing room volume is a little low.
The microphone.
I think the volume of the hearing.
Yeah, the architect.
Yeah,
is-
Mr. Scarano is here?
Yeah, he's in the room.
Excellent.
Okay, all right, great.
Mr. Scarano, please join, panelists. Wait till he, and then Mr. Schmidt can respond.
Okay, he's in the room now. So I think we have everybody from both parties.
Mm-hmm.
Okay. Mr. Schmidt, would you like to start? Generally, we will start with DOB, so.
Sure.
Their application.
Thank you very much. I'll keep it very brief. Madam Chair, I think that you summarized our position not only perfectly. well-
Excuse me, I'm sorry, DOB, can you state your name for the record? Sorry.
No, I'm
Just
so
state
sorry.
your
I'm so sorry. Jane Schmitz, Assistant General Counsel for the Department of Buildings.
Okay, thank you.
And what I wanted to say, just very briefly, is I think that Madam Chair not only stated our position very perfectly, but including that line about the definition of living independently, that was actually in an earlier draft of our submission that I took out because it seemed a little bit too complicated. So I appreciate that, Madam Chair, that you went a step beyond and you managed to see that and somehow, put together an argument that was implicit, but had not been explicitly made. So thank you very much for that. I also want to thank Commissioner Shetta for his very kind words about the Department of Buildings. it is a work in progress. We are doing our best to be better in every way that we can. Unfortunately, at least I only learn from my mistakes. It may be true for my own agency as well. So we will get better over time, but there's a few things along the way that we have to improve on. And then lastly, Commissioner Yoon, you had pointed out that the distinction between the cellar and the basement does have some importance. And I do want to just speak about that very briefly. Commissioner Shetta was exactly right when he said that the distinction between a cellar and a basement has no bearing whatsoever on the legal question of whether or not dwelling units were allowed on that lowest floor in 2012. The only reason I bring that up now, right, and I'm concerned about whether this is a cellar or basement now, is because institutional knowledge fades, right? Right now, the Department of Buildings is aware of this issue. Right now, the BSA is aware of this issue. Right now, 99 Sutton LLC is aware of this issue. And if we allow that lowest floor to stay as a basement, 15 years from now, 20 years from now, 99 Sutton might presume, oh, well, look, it's really a basement. DOB might accidentally think that it's really a basement. I think that just as a way to prevent future mischief or future misunderstandings, I think it probably would make more sense to change that to a cellar. And unless the board has any questions, that's really all I have.
Any other questions for Mr. Schmidt? No? Go ahead.
Is it your intention to change the description of the lowest floor from a basement to a cellar in your modification?
I think it would be, yes.
Do they need to like put?
Amend their statement?
Yeah, that's my question. Do they need to amend their statement / request?
I think they're, the original application,
Yes.
actually, that's
So my understanding, the original request was to
just
like,
to modify it was.
to modify regarding.
So you need to
and-
then,
That's still to modify.
it is to modify the CO, but the modify the CO to remove the units, but it didn't ask for the, I know you made that request at the last hearing, but it's
Yes.
not in the in your original filing, so.
Understood. I'll confer with my team and see what they think is appropriate. I just wanted to make that point.
Yep. Thank you.
Thank you.
Okay. Thank you all.
Thank you. Let's go to 99 South Place's representatives. Mr. LaBelle, would you want to start this off or?
I do, Chair.
Okay.
So I would address the issue with regards to the units in the basement, and then Mr. Scarano would briefly address the basement versus cellar discussion, upon which we would submit, given the chair's comments today and Mr. Scarano's understanding of the finding that it was a basement. So while we share in the commissioner's appreciation of the Department of Buildings for all the important work they do, we do not think that their work was done well in this regard and on this application. The DOB has failed miserably to satisfy what should be a tremendous burden upon them to revoke dwelling units in the cellar, in the basement of a building, based merely upon allegations of how they think their review went and their inability to produce any records whatsoever from the review that was done at the time. And so what we do agree with was that in 2011, when the 2011 certificate of occupancy was issued, they got it right then, that the 2008 certificate of occupancy was incorrect. And essentially the 2011 C of O was specifically filed to correct these conditions and to demonstrate in effect that there had been and continued to be occupancy of residential units in the basement since prior to the relevant time periods. And I know the chair cited 281-4 and the fact that these basement units would have had to have been existing for quite some time. And essentially what was likely done at that time was that in 2011, when the Department of Buildings specifically called out this question and said in their audit statement, quote, "Where did the additional dwelling units come from?" unquote, they answered this question to their satisfaction based on multiple levels of review, and they passed the audit. So it is a very simple thing, which is that this is the Department of Buildings' burden as far as this case is concerned. this is if an applicant, if a private applicant came to the board, if we were to come to the board on a variance application or other application with the evidence that has been presented by Department of Buildings and essentially claim that we couldn't find documents that had been lost from an audit which occurred a mere 13 years ago, I think that the chair and the board would have certain issues with regards to our ability to show what happened. And DOB, in essence here, failed to correctly show what happened. And it is the burden on them to demonstrate why the 2011 audit was incorrect, which they've been unable to do. So that's essentially the total of our argument, in addition to the papers which we've submitted. Again, we note that Department of Buildings has not apologized to our architect for the submission of documentation relating to unrelated cases, numbering over 70 pages, did not address that in their SIR reply. So this is very disheartening as both a practitioner before the board for 20 years, as well as someone who is regularly called upon to weigh in terms of architectural credibility and such. Department of Buildings did not address that. And in essence, we feel that they have failed their task here and have failed their burden, and we would ask the board to disallow their application. I know that, and Chair, obviously you probably have questions and such, but we also have Mr. Scarano here who can separately address the issue of the basement and the cellar.
So from what you're saying is that yeah, there are volumes of documents that are placed, and oftentimes applicants, when they submit to us, they're not able to find historic documents, and sometimes we need to piece the missing pieces and kind of come up with a reasonable answer, right? And that has happened with applicants also. And we have, in this case, the DOB has clearly acknowledged that there are certain missing pieces, be that as it may. How that missing pieces would have helped us understand the arrival of the issuance of the CO, I personally think it's irrelevant, because of if one looks at the way the regulation is written, and if someone followed the regulations the way the regulations were meant to be written, then there was no way that CO would have been granted, even in 2008, let alone in 2012. So I think having that paper trail, yes, would be helpful to know where the mistake was done. And DOB is acknowledging mistake was done and the mistake needs to be fixed. And the board entirely agrees that DOB has the right to fix the mistake. And the mistake is very clearly evident in the way the text is written, between the combination of the MDL, zoning resolution, loft board rules, and everything around it. So I think that is what we have been connecting the dots with, as to if one read the regulations as applicable, then would this CO should this CO have been granted? I think we have all we all seem to be reading those rules and regulations and connecting the dots and saying no, regardless of whether those documents were made available. Because there is nothing in those rules that says, however, an exception can be made. There is no exceptions that is highlighted, and nor have you been able to identify those exceptions if they were applicable in this particular case. And we are all looking at the same set of text and sections and subsections that you have also stated in your documents.
Chair, I hear what you said, but the difference is that I don't merely view it as helpful for the BSA to be able to provide the documentation and the evidence of the audit and what happened. I feel it to be critical in this regard, given the fact that the board's action here may result in 10 families losing their homes. And so what is more likely, Chair, and it's a common sense matter, is it more likely that the 2008 C of O was in error, and that upon looking, again, I quote the specific question, where did the additional dwelling units come from? That specific question called out that the 2011 C of O was issued correctly, or vice versa. And so I say that given the additional scrutiny that was done to arrive at the additional units in the basement, that it is more likely here from a common sense standpoint that the 2011 review, audit, and passing of that audit was done, it was correct, and that the documentation provided to DOB at that time was sufficient to satisfy that those had been longstanding residential units. So again, I feel that this is a critical point, and I again feel that the Department of Buildings has really terribly failed in carrying its burden. Any documentation, one piece of paper from the time, other than citing relevant areas of law, the affidavit testimony of anyone who was involved at the time, they've done nothing. They've carried nothing here. There's literally, they've given you sections of law and that's really it from that time. So we don't know what was presented at that time, but we do know that the 2011 audit specifically looked at this and found that they had satisfied the requirements. There were likely inspections done of the units at the time, as DOB does prior to issuing the C of O. So while we differ on the application of these provisions of the MDL, I will say that, you know, again, merely from a standard of case law and what the burden of the Department of Buildings would be in such an extreme action as they have failed to meet that burden.
Commissioner
think
Brown,
given-
and then Commissioner Shetta.
I think given the inability of DOB to uncover the documents that are being referenced back from when this first happened, the fairest way to proceed would be to talk about the laws in effect at the time and how they are applied when analyzing your case, because to sit there and try and figure out what might have happened can cut both ways. It could cut against DOB, but it could just as easily cut against your client. And so therefore, I think the safest, fairest way to approach this would be to talk about the law and the law's applicability to the situation at the time. So I think that DOB as well as the BSA is approaching this in the fairest manner.
Well, Commissioner Otley Brown, I'm glad that you brought up fairness, because there is definitely a role to play in terms of fundamental fairness and equity, which is not being discussed in the course of this hearing. And it will at some point be raised because of the fundamental unfairness of the action being taken by DOB right now. But in essence, the one area I would say that the DOB cannot prove victorious here is in their satisfaction of a burden of proof. If there is a burden of proof that is incumbent upon them to, again, and commissioners, we know while we appear before the board many times during the course of a year, actions for revocations or modifications of C of O are relatively rare in that regard. And so the burden here is we're not talking about fairness. What we're talking about is whether or not DOB has satisfied its burden. There are cases which we have cited which demonstrate not only that DOB must satisfy its burden, but there are certain presumptions against DOB which would lie to the extent that they're unable to find their documentation and produce that documentation. And there's other cases which support the fact that to the extent that this was an issue surrounding paperwork and that the conditions at the time demonstrated legality in terms of those units and that the filings were in error, that the filings in essence would be able to be fixed in order to make that up. That was what was done in 2011, as is our contention. And again, we heard the board's comments. I understand the board's position, but having said that, we do feel that as far as a burden here, that the DOB has failed to meet its burden.
Thank you. Commissioner Shetta had a question.
I'm not sure what was wrong about the 2008 C of O. Do you mean that 10 units were there and the certificate didn't reflect that, and then you speak to, if you're asserting that, how come that the drawings that were filed didn't reflect such that
The drawings, those drawings were in error.
Mr. Lovell, please
Of course.
let Commissioner
The
Shetta.
pre-2011 or 12 drawings clearly indicate that the space in the lowest floor, I'm not going to call it cellar or basement, the lowest floor space contained accessory space to the units on the first floor. It didn't reflect apartments. So how do you want us, by the argument that the 2008 certificate of occupancy was issued in error and the 10 units actually were there before 2011, and that, of course, I'm anticipating that you're going that way.
Yes.
To prove to us that the amendment that excluded cellar/basement is not applicable. we do have drawings, we do have a certificate of occupancy, we do have consistency between both of these documents, and you're giving us nothing to prove that the 2008 certificate was issued in error. What is your
Yeah.
proof to that?
Yeah, so it's important to note that it's not my burden, right? So I'm the respondent here. It's the applicant's burden to demonstrate why that decision that was made in 2011 was incorrect, and the 2008 that we should go back to the 2008 certificate of occupancy. So again, it's our contention that the 2008 materials in terms of plans that were submitted in support of that C of O that was issued were in error, and that the 2011 submission was done to correct that error. Moreover, that 2011 submission was reviewed, audited by DOB, and approved after inspection. That is our contention.
So you're saying that your applicant, the owner, made a submission, that's an error against his interest, and then DOB actually went to the site and corrected the error and issued a new certificate in 2011 to add up the 10 units?
That's exactly what happened. That 2011 certificate of occupancy, which was again done as a after audit, they specifically, I mean, Commissioner Sheta, they specifically looked at this question: where did the extra units come from? And then after multiple levels of audit at Department of Buildings, including inspection, determined that they were sufficient, and they were given sufficient proof at the time to establish the legitimacy of those units. That is exactly our contention.
I don't want to go back and forth. I go
Of
back
course.
to, I want to go back to what both Commissioner Otley Brown and I said. Absence of these documents, we are trying to level the playing field and trying to, I really believe this is how interpretations of zoning regulations and other things are happening. And same thing in the way we are reviewing the appeal for a revocation is what laws are applicable and what laws were applicable then when the CO was issued. Error was made. An error was made based on what? If DOB is saying there was an error made, we have to verify, was there an error? And how does an error based on what? It has to be based on rules. And that's why I'm saying is when I read through these rules, it was interesting reading these rules. The subsections that were all there, it was quite interesting read. It took me almost 2 days to get everything together. So all I would say is reading this, I did not see an exception anywhere in the text and I was looking for them to see whether the exception would have applied, but there weren't any. It was very clear. It was you are eligible if you do X, Y, Z. You're not eligible if you're that. There was just very clear. And when I look at the text, the way it's written in the loft board rules and in the MDL, I really do not see an exception that would have applied in this case. So it is possible that when it was approved, an error was made in its interpretation. Be that as may, none of us were there in the room, at least except for Mr. Scarano, none of us were in the room.
Right.
So we have to then apply what was the law then and how the law is being applied. And I think that is the fairest way to look at it, and nothing more than that. I think a lot of the arguments you're stating, it may be something for you to set the record for your next situation, but it is not for this.
Can I add just something quickly?
Okay.
I believe that the argument that the applicant is putting, the respondent is putting before us is intact. There are many ways to prove that. If there were
it is the burden of proof is on DOB, and DOB has made it very clear, whatever documents they have, this is what they have, but when you apply the law, this is how it is to be read. And if the applicant had those evidence and could prove it to benefit them, I'm sure they would have provided it. Right? If they don't have
that's what I
it,
wanted to say exactly.
if they don't have it, that means they too.
For example,
So
utility bills for independent space
Right.
in the basement. If you have that, bring it, we'll take it.
okay.
But
Chair,
you have
I would just close because again, without any more back and forth, we were involved with a case, Gravi versus Srinivasan, a case that was in a different context, a vested rights case in 2008 that was brought against a board determination regarding vested rights. And importantly, in that case, the applicant there had submitted a site plan that was stamped by the project architect instead of a licensed survey. And so, as the chair and the commissioners note, the importance in terms of invested rights analysis, that you have valid permits, that is a validity of the permits in a vested rights case is of critical importance. And so Department of Buildings in that case, Gravi versus Srinivasan, again, which was eventually decided by the Court of Appeals of the state of New York, the board supported the DOB's contention in that case that because the applicant there had submitted a stamped site plan instead of a survey, that they had not respected the technical requirements of filings at DOB, and so found that the permits had not been validly issued. And eventually, after the case went through years and years of litigation, what it was found was that that was not the case, that essentially you can't basically put something down of this importance, in that case, the importance of a vested rights case analysis and property rights, to something as minuscule, as ministerial, as a submission of a survey. That if DOB at the time, their actions spoke louder than their words, they accepted the submission of that site plan at the time, and they allowed the application to proceed. Here, similarly, our contention is that DOB's actions spoke louder than their words, that they basically did the analysis at the time, found that the units in the basement were satisfactory, and not merely allowed the application to proceed to C of O, but didn't disturb that determination for over 12 years. So, Chair, again, we respectfully agree to disagree in this respect, but we close by saying that we do indeed feel that DOB had it right in 2011, and they have failed to meet their burden here.
Thank you. Any other questions? It seems, Mr. Schmidt, you want to add something?
Yeah.
Any other questions from the commissioners? Okay, Mr. Schmidt.
Thank you, everyone. I do want to make two comments. And one is a question about procedure, which we were just addressing the last time I was up. As far as comments go, Mr. Shetta, thank you very much for reminding me that the plans submitted in 2006, drawn up by the architect for 99 Sutton, indicate that those the spaces on the lowest floor did not have a stove, did not have a three-piece bathroom, did not have, many of them didn't have bedrooms. They were clearly, there's an open spiral staircase that went from that lowest floor up to the first floor. They were clearly accessory use. So theoretically, maybe those plans were drawn up in accident, and who knows how they were submitted. There was a mistake on the part of 99 Sutton when they submitted that. But I also want to note one thing. If what Mr. Lobel is arguing is that these units existed in the lowest floor and always did exist in the lowest floor, right? And they were therefore somehow they qualified as residential use things covered by the loft law through MDL 281 sub 4, right? And always were part of 281 sub 4. That would require that there was residential occupancy in those spaces since the early 1980s through 1987 until whenever it was, the 2008 CO. I want to draw your honors, commissioner's attention to, I think it's exhibit 1 of my most recent response, which is the registration renewal invoice from the year 2000. 99 Sutton LLC has submitted this in their own papers at various times. That registration renewal invoice from the year 2000 lists 31 dwelling units, all of which correspond to the 31 units on the particular floors shown in the 2008 CO. So what Mr. Lobel is arguing is that somehow not only did they draw up these plans in 2006 that didn't reflect that there were really people living there independently, but then when they were trying to register these units with the loft board, they somehow, they forgot about these 10 units in that submission. I would note that in, I think this is exhibit 2 to my most recent response, there is a report and recommendation from the loft board in 2017 that states, for whatever it's worth, that these 10 basement units are not IMD space. So really, that's all I have. I just think the idea that the 2008 CO is an error when the 2008 CO actually matches the plans that were submitted, matches the loft board submission that 99 Sutton LLC filed. I think those pieces all connect up quite nicely. And then the procedural issue I have, Judge, I'm sorry, Madam Chair, is that in our January 30th, 2024 submission, we do note that we are asking that the basement should be modified to read cellar. Now, granted, that was I think our second written submission. I know it's not our first. I'm just wondering whether or not that suffices or whether or not we would need to modify the application.
We can, I think this is something at our executive director, General Counsel would reach out to you. I think this is more of a pro forma of the
Sure.
submission process.
Okay.
Okay.
That's all I have.
Thank you.
Thank you.
Mr. LaBelle's hand is up, if you wish to allow him to speak.
Yes, go ahead, Mr. LaBelle.
Thank you. I would really just say that in terms of whoops, they forgot that this is, I'm not sure if Department of Buildings truly appreciates the level of seriousness of these proceedings as well as the actions they are seeking the board to take. But I would say that if whoops, they forgot is applicable here, it's in the Department of Buildings papers, which say that the 2011 job evidently passed its audit, though the department no longer has any record of what discussions were had or what explanation was given. So that's really-
Sorry, we just lost the connection briefly. Can you just repeat that last sentence?
I would just repeat the department's own words, which is that in the 2011 job evidently passed its audit, though the department no longer has any records of what discussions were had or what explanation was given. So in terms of erroneous action here, I would put it less on the applicant who does not have a burden here and put it on the department, which has, again, failed to produce any records of its review.
Okay, thank you.
Thank you.
Any other questions or comments on this? I don't think there would be any public participation on this. We can open it up to public if need
Oh,
be.
Chair, there was a second issue we were just going to discuss, which I think Mr. Scarano was merely going to submit on the issue of basement versus cellar and the chair's calculations as were evidenced in today's review session.
Well, with regards to the basement and cellar, I'm not sure what additional information can be provided because the zoning text, once you put in all the elements of defined terms together, it is very clear how the space should have been, I want to be very clear, should have been read as cellar and not as a basement. So again, what may have been submitted at that time and based on what they may have reviewed it, it is subject to correction. And so I'm not sure, I mean,
Well, Chair, given the fact that the department's submission right now, as is evidenced by their cover page of their application, does not even yet reflect the fact that the application by the department here is to reclassify the basement designation on the certificate of occupancy. We can merely submit responsive papers when they do provide such documentation. Mr. Scarano says that as a matter of precedent and in terms of measurements, individual measurements at the building, that he can present the board with sufficient proof, particularly with regards to the location of the building at the street line.
Mr. LaBelle, at the initial hearing, this was discussed at a length.
Understood.
And as a matter of fact, Mr. Schmidt did present a diagram when he claimed that that's why he chose law and not architecture. He presented that and went through the calculations that were based on the documents that were approved at that time and how that wouldn't have led to this site being qualified as basement. And at that time, Mr. Scarano did talk about it. So, and the board had asked the applicant to provide all the justification. So I'm surprised why an additional submission would be needed for you to counter that argument. That Mr. Schmidt had made it very clear that he wanted to clearly amend it by stating that that'd be the other part of the amendment. So it's not lost on any of us. It's just a more of a pro forma for that to be revising the formal submission, but it has been stated publicly, and Mr. Scarano spoke to it, and we discussed it. So I'm not sure what additional submission can be made that would reflect a different set of evidence other than how zoning resolution reads it, specifically tells us to apply it.
Chair, given that Mr. Scarano is with us at the hearing and that the chair did express at the executive session her review of the text and calculations, can Mr. Scarano speak briefly to this, merely to frame the potentially the submission he would make?
What happened? Okay, so
I believe it's the connection to the screen. It's not that. This
I
one.
just want to make sure everybody can hear us and we can. Mr. Scarano, do you want to speak to the basement and cellar?
We can't hear you. You're muted.
Mr. Scarano, can't hear you. You have to unmute.
Is that on now?
Yes,
Yes.
sir.
Go ahead,
Hi.
Mr. Scarano.
Yes, Robert Scarano for the applicant. I just want to make one very brief point, which we will submit further clarification on. And that is that the base plane calculation, while it is correct, takes place at the street wall line level. Typically, all buildings that are on the street wall line level utilize grades that are beyond the property line in order to establish the base plane. That is traditionally how it's done and could only be done with buildings that are on the street wall line level. So the representation that was made that the grades beyond the property line are not used is really incorrect in how it is actually done in the field. And that is that any grades beyond the property line are utilized for the base plane, which in this case also include those grades at the open area, which is depressed from the sidewalk, and that's why they were used. And in very many cases, this is how the department also justifies their heights and requires applicants to measure from these depressed lower areas. So that's what I will submit a little further clarification on, because I think the chair's understanding that the grades only are taken from grades on the property line are not correct when you have buildings on the street line.
Mr. Scarano, if you did not hear me correctly, I will repeat it. Way the definition of the base plane is, it says street wall line and street wall line level. Those are the two very defined terms. And in this case, the building street wall line is right on the front lot line. So there is no setback from the front lot line. And the street area level applies when the building is set back from the front lot line. And then you're measuring the grade. And look at the diagram. The zoning resolution has a very clear diagram with regards to what is a street wall line level, where it shows a building is not sitting on the front lot line, it is set back. It's the shallowest distance of the street wall, and the distance between that can be used to determine the base plane. In this case, the shallowest distance between the street wall and the front lot line is 0. Because it is sitting right on the property line. The fact that there is an areaway in front of it that is within the city sidewalk, I don't think that's how the zoning resolution is written. Zoning resolution says if you have an areaway within your property line, and in this case, it's not the areaways that are located in the rear or to the side, it has to be in the front. So the zoning diagram, which has been in place since 1990s or so, has been very clear. It has not changed, and the definition is very clear. So what may have been, how it may have been determined, I question it because it's very, very clear. And I remember Commissioner Yoon had made a statement regarding that at the last hearing. Commissioner Otley
I want
Brown.
to add also that I believe that DOB also did the analysis using Mr. Scarano's base plane and still proved that it was a
Yes.
cellar
Yes.
by 40% of a foot.
Yeah.
I just want to say also for the sake of discussion, the street wall line level is the mean level of the natural grade at the street wall line. Yeah, I obviously have not practiced as long as many people here, but I was never under the impression that DOB would approve a base plane calculation using areaways in order to determine the height of the building. Because my understanding was that we needed to rely on this definition of street wall line level, which is the mean level of the natural grade, not the artificially constructed areaway grade. That is my personal experience. I would need someone at DOB, a plan examiner, someone to confirm that, but that has always been my understanding. Just for the sake of this discussion.
Yeah, thank you.
Yeah, that's a very important point, actually. I do believe that considering areaways, if they are within the law, is kind of, I would say, tricky to the zoning resolution. I don't think an average, absolute average, which is this plus this plus this, divided by the number is a fair value for the base plan. I would say it should be based on a weighted average that reflect how big or what is the extent of that areaway. I would urge actually DOB to look into that.
Well, I think this text is very clear. There is really no room for interpretation on this. But if both parties want to submit something to that, it's, in my mind, as I look through the text, I just do not see any. And the diagram is very clear.
Yeah,
One should
I
look at the
agree.
diagram. It should
I'm not
be-
talking about this case, Madam Chair.
No, I'm not talking about, I'm talking about the zoning resolution diagrams and how one defines each one of these defined terms. Street wall line level, street wall line level. And how one, and therefore, once you put all of those elements together to define how you measure base plane.
Chair, we would like to submit.
Yep, go ahead.
We would like to submit.
Okay, what I am going to, do we need to go to public on this?
Yeah, we need to go to the public.
Let's go to public. Is there anything else that anybody wants to say? Okay, if not, let's go to the public.
Okay, the case that we're currently discussing is 2023-40A, 9911 Sutton Street, Brooklyn. If you wish to discuss, dial 646-518-9805 or a toll-free number, which is 888-475-4499. At the prompt, you will enter the webinar ID number enter the webinar ID number 826-3691-0894 and press the pound sign. At the next prompt, you will press the pound sign only. Once you're permitted in, you will press *9 to raise your hand, *6 to unmute if you're calling in on the phone. And if you're in the Zoom room already and wish to participate, please raise your Zoom hand, which is the little hand at the bottom of your screen. Why is there feedback? Once you are permitted in, you will have 3 minutes in which to discuss.
I will allow a submission no more than 5-page, including all attachments, exhibits, to provide a clarification with regards to both the basement versus cellar and also with regards to anything that you may want to repeat with regards to why those units in the basement are, the CO should not be revoked. And this is for both. And both shall submit it simultaneously.
Okay, Mr. LaBelle's hand is up.
Go ahead, Mr. LaBelle.
Chair, I would ask, given our conversation internally prior to the BSA hearing today, that we be allowed to, in addition to the 5 pages, Mr. Scarano has indicated that there are precedential decisions at DOB that would clarify this. May we exceed the 5 pages if we're submitting?
Mr. LaBelle, both of these issues that we are discussing today was brought up at the initial hearing. And I did not put any limit on the submission because I wanted you all to provide everything that was evident. And now this point to say this is a new discussion and therefore we need to provide a new set of documents and need additional, I do not think that is fair because everybody, we all have really reviewed every document that that was given. And I don't see the evidence that you should have provided that evidence at this point.
So the chair would not allow us to exceed the 5 pages.
I believe the chair has stated as such.
Thank you.
Yeah, five-page submission if you want to devote just to the basement, just do that. That's your choice. Yeah, I mean, I'm not even going to ask why why it was not submitted beforehand.
I think that there was certain discussion that took place today at the executive session, which rather clarified the board's statements with regards to measurement at the street wall, which Mr. Scarano responded to. But again, obviously, it's at the discretion of the chair.
Right. Please go back to the December hearing and look at the videos and look at the PowerPoint that was presented by Mr. Schmidt to clearly walk us through how they came to that conclusion. And Mr. Scarano stated exactly what he stated today. And we questioned it exactly the way we raised it today. No different, but we just backed it up today with more of the zoning and zoning rules and regulations that applied then and applies still today. And so you had till January, till March to make all the submissions for both those sets of arguments. Okay.
So no one has called in and no one has raised a hand from the outside.
Okay, I want to make a recommendation. I want to close the hearing, and records will be kept open for submission from both teams, 99 Sutton and DOB. It will be simultaneous submission, and it's a 5-page submission. That includes, that summarizes your position.
Chair, we would also request that to the extent that there was obviously issues that the board wished to discuss, that the board would be able to reopen to discuss those.
Sure.
Thank you, Chair.
Yeah, thank you. Motion to close?
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Commissioner Sheta, can you repeat that again? Sorry.
Sure, I vote aye.
Thank you.
Okay, we will reach up, I think you all the time that you need to make the submission. Maybe we'll schedule this in June. There's a hearing in June, so that should give you all enough time to make the submission.
So you want a simultaneous submission, Madam Chair? For both?
Yes.
So if we're gonna do June 10th, would be May 28th would be the latest then?
Yeah.
Okay, that's if we're doing June. We'll get back to you with a schedule. Just to confirm availability and stuff. Okay.
Thank you.
Yeah.
Okay,
move on or?
do you all want to move on? Okay, all right.
Okay. Special order calendar, continued hearing 508 80BZ 6220 14th Avenue, Brooklyn.
This
Mr. Goldstein.
Goldstein, is he in the room? Yes, he is.
I don't think I'm a panelist.
Oh, you're not?
No, just unmuted.
Panelist, yes. I just did that. Changed. Okay. Are you now?
Now I'm a panelist.
Okay.
How are you?
Good afternoon. Is anyone joining you, Mr. Goldstein?
Just me.
Okay, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Please state your name for the record and proceed to respond to the board's comments at review session.
Good afternoon, Jay Goldstein for the applicant. I don't believe there were any comments for us at the review session.
Yeah. Any questions for Mr. Goldstein? Let's go to the public.
So the case we're currently discussing is 508 80BZ 6220 14th Avenue, also known as 1383 63rd Street, Brooklyn. Should you wish to comment on this application, please dial 646-518-9802 or a toll-free number, which is 888-475-4499. At the prompt, you will enter the webinar ID number 826-3691-0894 and the pound sign. At the next prompt, you will press the pound sign only. Once you're permitted in, you will press *9 to raise your hand, *6 to unmute if you're calling in on the phone, and if you're in the Zoom room already, please raise that hand that is in the bottom of your computer screen. Once you are recognized, you will have 3 minutes in which to discuss. Excuse me.
Okay. I'm going to recommend that we close.
We still have a minute. Excuse me.
Okay.
Time has passed. No one called in.
All right. I'm going to make a motion to close.
Chair Shonda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye. I mean.
Commissioner,
Aye.
did I just, oh, okay. Commissioner Estrada,
Aye.
Commissioner Yoon.
Aye.
Okay.
We will schedule this for early May.
Thank you.
Please note that there are outstanding items that the applicant is working on regarding noise and hazmat.
Oh,
Right. Those are items that we had a conversation between myself and the board on Thursday or Friday of last week to try and resolve how to proceed with certain questions.
You mean the board staff, not the board itself?
Sorry, yeah.
Yes, please make that clear.
Thank you.
okay. So in that case, if everything comes through, then early May, otherwise it will be once we have all the clarification.
Understood. Thank you very much.
Thanks.
Okay, thank
Bye.
you for the clarification, Ms. Benke. Okay, next.
New cases, item number 21-30700BZ, Volume 3, 4102 Main Street, Queens.
This would be someone from Mr. Lobel's office.
Amanda Iannotti.
Yes. Yes, she should be joining in as a panelist.
Anyone with you, Ms. Iannotti?
Hi, good afternoon. No, it's just me.
Okay. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Please state your name for the record and proceed to respond to the board's comments at review session.
Amanda Iannotti on behalf of the applicant. I don't believe there are any comments at the review session, but we'd just like to thank the board for your review and for the additional time, for a total of 24 months for the extension of time to attain a CO to make sure they have sufficient time this time around to get it. So thank you.
Okay. No questions or comments from Miss Iannotti? Okay, let's go to the public then.
The case we're currently discussing is 30700BZ Volume 3, 4102 Main Street, Queens. Should you wish to discuss, please dial 646-518-9805. At the prompt, you will enter the webinar ID number 826-3691-0894 and press the pound sign. Thank you. Press the pound sign. At the prompt after that, you will press the pound sign only. Once you're permitted in, you can press star 9 to raise your hand, star 6 to unmute. If you're calling in on the phone, sorry. And if you are in the Zoom room already and wish to comment, please raise your Zoom hand, which is the little hand at the bottom of your computer screen. Once you are recognized, you will have 3 minutes in which to discuss. Waiting for the clock.
Okay. Did the time run?
No, it's got 36, 34.
Hold on. Okay, great.
Okay.
I'm going to make a recommendation to close.
Chair Shanda,
Aye.
Vice Chair Shabeta, Commissioner Otley Brown,
Aye.
Commissioner Shetta, Commissioner Yoon.
Aye. I'm
Okay.
going to put this, schedule this for decision early May.
Thank you.
Thank you.
Thank you. Zoning calendar, new cases. Item number 22, 2023-71BZ, 504-510 East 62nd Street and 511 East 61st Street, Manhattan.
This would be,
Hillary Hamburg, and I don't know who else is coming in with her. There's a few other people here.
yeah, I do see, I'll,
Okay. Panelist.
Harry Hamburg, I don't see Hillary.
Hillary, yeah.
Oh, there I see Hillary also. Anyone else?
I don't know if she comes on the screen. Good afternoon, Ms. Hamburg. Is there anyone else joining you in this team?
Yes, Helen Irving.
Helen Irving.
Yes. Okay,
Anyone else? That's it?
No, that's it.
Okay, Ms. Irving, can you unmute and join us, please? Thank you. Okay, please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to the board member questions?
I do.
I do.
Please state your name for the record and proceed to respond to the board's comments at review session.
Good morning, Madam Chair, or good afternoon now, Madam Chair and members of the board. My name is Hillary Atstrat Hamburg. I'm a partner at Venable LLP on behalf of the Schwarzman Animal Medical Center. I am accompanied today by Helen Irving, the president of the Animal Medical Center. She is here on the Zoom to address any questions, although after attending the review session, I believe most of them are directed towards myself and questions regarding the application more generally. So we will certainly provide a supplemental submission, which provides some additional graphics and views. We appreciate the board's questions regarding why this height is necessary, why this is the minimum necessary for relief. We're also happy to provide the video and try to insert the graphics directly into the video as well, especially for those who were unable to attend the site visit. In the interim, though, I did want to take this opportunity to briefly explain the rationale for this sign and directly address a few of the questions that were posed. First, in terms of the views that are going to be most benefited by this sign, yes, this sign is part of a larger wayfinding program that is being implemented as part of the overall redesign of the facility. But there's really 3 different locations that would be most benefited by SG12, which is the proposed sign. First, for those who are traveling by foot or by vehicle, west to east on 62nd Street, I certainly agree, and SAMC agrees, that the goal for the new 62nd Street signage is to assist in wayfinding when traveling down 62nd Street. But in an emergency, when someone has their animal, they're very stressed, it is possible that they aren't going to see that signage and might make that incorrect right turn from 62nd Street onto York Avenue. And in that instance, without additional signage that's at a greater height than what is permitted as of right, any signage would be blocked at that level on York and 62nd. So we can include additional views of that location in our video and our next submission. But that's one key view that is a concern, that someone's going to think, oh, I'm not going to go straight through the intersection of York and 62nd. I'm supposed to turn right. And they think that the main entrance is going to be somewhere along York Avenue, which is not correct because of the Bentley Hotel.
I have a question. So the proposed signage on the south side of that frontage would only mention the name of the facility. It wouldn't say go to 61st Street entrance because even if one sees, let's say I make the mistake and I make the right turn and I see the building, but if I'm going towards that sign, there is no entrance on 61st Street. I still have to go to 62nd Street, right?
For the main entrance, yes, that is correct. There is a parking entrance as seen on the site plan. There is one entrance along 61st Street, but it is not the main entrance to the lobby or to the emergency facility. Really where it comes into being most helpful is simply identifying the fact that the building the person ultimately needs to get to is the back building, the setback of the Animal Medical Center, and not something related to the Bentley Hotel.
Right. I think the signage on 62nd Street that says entrance and this way and all, that is going to be the most critical. That is the entry point. There isn't any entrance on 61st Street. It is that is the only entrance point. Okay. So yeah, again, do provide the video to help us walk through it. That can help the narrative that you've presented.
Sure.
you can just see my skepticism on that. I see the sign, but I still don't know where the entrance is.
Understood. I think that frankly, the two most crucial views are the next two that I'm going to discuss. The first is for pedestrians traveling west to east on 61st Street. So this is one of the key pedestrian access points because many pedestrians are traveling from public transportation in the 59th Street area, 59th and Lexington, over to the site. So they would come down 61st Street on the southerly side of the sidewalk on 61st Street. And their first point of trying to identify the medical center is going to be on 61st Street. And I can say I did have the opportunity to view the images from your site visit. It is substantially more challenging to see the hospital and the signage when there are leaves on the trees. I have been to the facility both in the winter and in the spring and summer where there's leaves on the trees. And those mature trees on 61st Street, if you are on that southerly sidewalk, greatly block any visibility of the facility if the sign is at a compliant height. So we can provide additional views on 61st Street that really show the obstruction that occurs from those trees as you are a pedestrian on the southerly sidewalk on 61st Street. And again, that's a key pedestrian access route based on the location of public transit in the area. And then lastly, the key view is traveling either by foot or by car south to north on York Avenue. Again, Chair, I understand that you had a site visit and you had some questions about that. I'm happy to provide additional video of this area. As someone who is always traveling to the site by foot, I can attest to the fact that when you are in the crosswalks and you are a pedestrian on York Avenue, there are several viewpoints in which the facility signage would not be visible. So again, I heard the comments on that. We're happy to provide the additional viewpoints, but especially now that that southerly facade signage, which is going to be lowered, will not be there, having the heightened sign still does provide visual access for those traveling south to north. And again, we're really looking at from the wayfinding program perspective, that reduced height of the southerly facade sign is there to benefit those exiting FDR Drive, which was a very confusing point. And so in order to make up for the fact that now we're having that reduction for those traveling from south to north on York Avenue, having the higher signage does provide a visual benefit for those traveling up York Avenue. And we will show that in the video that we'll provide.
So just for your benefit, I did take photos and videos from that north approach on York Avenue, both from the street level driving and from sidewalk levels. So, you can look through those, and if you want to just use those to superimpose your arguments, or you want to use your videos, that's fine. I just want to, if you want to save you time to go and do the video.
Appreciate
Not that I'm a very good videographer.
I will take another look and see if they are the views. Again, I'm very familiar with this site. I've traveled to it on a number of occasions. So I certainly know the areas where I personally found at the community board, several community board members actually spoke to the points where they found visibility to be very challenging. I also just did want to note in terms of the minimum variance, we are located across the street from MSK's ambulatory care facility. And so this location of the proposed sign, while it is in direct illumination and there won't be any huge light spread or anything of that nature to any of the surrounding buildings, just from a neighborhood perspective and from being a good neighbor to those directly across the street, having the sign at the proposed height actually reduces any visibility from MSK's patient floors where people would be receiving treatments. I believe the top floor of MSK is their cafeteria facility, which isn't operational as much during the times when the signs would be on as the lower floors. So again, not going to have light spread, but just in terms of aesthetic appeal to those directly across the way, we actually believe that this proposed location has less of an impact while still getting all of the visual needs that as a Schwarzman Animal Medical Center has. In terms of the board's other question, I know that Commissioner Shetta asked if there were any violations for the southerly signage. The answer is no, not in DOB Biz or DOB Now. And I did want to make clear to the board that it is our sincere belief that that southerly signage is legally non-compliant and original to the building. We pulled tax photos from the 1960s and 1970s of the whole building, but only unfortunately the northerly facade and the easterly facade had tax photos. But all the signage is the exact same type of lettering and all seems to be approximately the same age. So we do believe it was all part of the original construction of the building, which would make it legally non-complying. But we did not want to formally represent that because we simply could not find anything in DOB records or in the tax files to confirm with absolute certainty. But we are quite confident, based on what we have found, that it is legal signage on the southerly facade. So we wouldn't expect any violations. And in terms of the question of illuminated versus non-illuminated versus signs with indirect illumination, really when it comes down to illuminated signs versus signs with indirect illumination, the big difference is the type of light source used and the projection of the rays of lights. So an illuminated sign, the purpose of it is to have a reflection of light from an artificial source, and a sign with indirect illumination is specifically designed so that there are no direct rays of light that are projected. It's all just like a gentle backlighting that doesn't project onto any residential buildings or onto the street. And that was included in the cover letter to our NOC submission as well, but we're happy to include it in any supplemental submissions.
Right, and in your rendering also, oops, I'm sorry, in your rendering also you can show that as to how that would be. I think it's pretty common, as I said, I see that is now as a new norm.
Agreed, especially on community facility buildings. I think that this is the standard signage that's used, especially in Manhattan.
Yeah. Okay. I think from what you have heard from all of the, I think the ask is minimal. It's just the reasoning behind this. I'm trying to connect the reasoning and the ask, and while I think it's reasonable what you're asking, and given the location of it and the difficulty in seeing the building, I think if you paint it in a completely different color, it'll stand out from the Bentley Hotel. That's one thing. Just kind of like everybody will like, oh, that yellow building, I know which one is that. You know, I'm just joking, sorry. But I think, yes, signage is needed, especially when approaching from FDR Drive. And there is only one entrance, which also makes the signage very critical. How do you direct somebody coming by car, that they have to make those sets of turns to get around to it, and those become critical. So yes, those are all needed. And I really do think the signage improves and helps the situation. But you need to clarify that last bit of that signage through these additional information that we are requesting.
Understood, and we're again happy to provide it. We will work with our design consultant and the architects to get everything that's needed.
Yep. Okay.
And I think that addressed all of the questions that I heard at the review session.
Okay.
So happy to provide the supplemental submission. I think that we could probably have that ready in the next 3 weeks or so.
The next hearing, well, let me first ask, do commissioners, do you have any other questions or clarifications that you want from the team? Okay. Let's first go to the public.
The case that we're currently discussing is 2023-71BZ 504-510 East 62nd Street and 511 East 61st Street, Manhattan. Should you wish to comment, please dial 646-518-9805 or a toll-free number, which is 888-475-4499. At the prompt, you will enter the webinar ID number 826-3691-0894 and press the pound sign. At the prompt after that, you will press the pound sign only. Once you're permitted in, press *9 to raise your hand, *6 to unmute to call if you're calling in on the phone in order to be heard. And if you're in the Zoom room already and wish to be acknowledged, please raise your Zoom hand, which is the little hand at the bottom of your computer screen. Once you are recognized, you will have 3 minutes in which to discuss.
The submission date for the earliest May hearing is April 18th, which I think will be too tight. I would suggest May 20th because the submission date for that is May 2nd.
That would be fine. Thank you.
Waiting for the timer.
Yeah. I think the other part of the argument that that may be of help to you is the signage that is there on the Bentley. I think it's a pretty large. It's a legal sign, I believe, but that's not on your property. But that also blocks the view when approaching from York and from 61st. So you do need a certain height. And I think you should factor that into your analysis to help make the argument why even the 40-foot high wouldn't work. Therefore, you need something higher than that.
Understood. We're happy to add that information. And SAMC has actually been in the situation where the community board thought that that signage was on the SAMC property because even local members of the community get confused by this site and this location. And we had to explain that, in fact, that billboard is not on our property.
Right. Yeah.
Okay, no one's raised their hands. No one's called in.
I just have a question. Was Bentley Hotel, was it ever used? I believe it was used as an office space before. Was it used by the hospital, the animal hospital? No. Okay.
No, but Madam Chair, you're correct. It was previously very early in its history an office building, and then it converted to a hotel. And now actually, I believe it's whether temporarily or permanently vacant. It's not being operated as a hotel at the moment, but it's still branded as the Bentley Hotel.
Okay, great. Thank you. Okay, thank you very much. Good seeing you. And we'll see you on.
Are you going to close or are you going to continue this?
No, that's part of the finding. That's part of the
Let's
minute.
continue. Okay.
So sorry, continued.
Okay. Just checking.
Thank you.
Just checking.
Thank you, everyone.
Okay. All righty. Thank
Bye.
you. This concludes the public hearing for April 15, 2024. And Mr. Sofior, if you have not heard your case, we have a hearing on tomorrow, April 16th at 10 a.m. and maybe one of your cases are there. Thank you.
Thank you, everyone.